Welcome back to the second segment of this law session on contract performance and breach. Now, before the break, we were looking at the rule relating to discharge through full performance, where it applies where there exists an entire contract. Now, where it is possible, as I said earlier in the last segment, to divide a contract into separate parts, example, if a sum is payable in an agreed reference as it relates to, say, a per week or per hour, then the courts, of course, will look at that in order to mitigate the situation. Now, a case to consider, of course, is Ritchie and Atkinson in 1808. By contract, the claimants had agreed to carry a cargo of specified quantity of hemp and iron as well. Now, the price agreed was £5 per ton for the hemp and 5 shillings per ton for the iron. Now, the claimant only carried part of the agreed quantity. The defendant argued that the contract had not been fully performed and therefore no payment was due. The court said that the contract could be divided into separate parts as the parties had agreed on a price per ton. Now, as you can see, the divisibility in that case was because there was some kind of reference point, and in that it was based on the weight. Now, the claimant was entitled to payment for the amount carried, the court said, although the defendant was entitled to damages for non-performance in relation to the amount not carried. So, you will certainly get some sort of relief, and equally you may be able to argue that there should be obviously a deduction for that part as it relates to the non-performance. Now, what about substantial performance? Well, there is a further exception that says in a situation where a court is satisfied that substantial performance is present, then that may also mitigate the harshness of the entire agreement situation. The court may then award the contractually agreed price and deduct the sums to reflect the amount not performed. If, however, the performance is not held to amount to substantial performance, the claimant is entitled to nothing. It may sound pretty straightforward to say, well, if you've substantially performed, then you ought to get something, because the point here is where you don't have, say, a particular reference point. It is not referable to a per ton, per day, per week, per hour. Rather, think of a situation: you get someone to come to your house and do some painting, and they have painted the living room perhaps and one bedroom, and there's 2 other bedrooms and maybe the lounge that needs doing. The point here is, can you consider, for example, substantial performance and whether it has been done? Well, the difficulty arises as to what amounts to substantial performance. There is no precise limit set down, but what you have to do is, in order to determine it, you'd have to look at the facts of the individual case. Now, sometimes what the court does, of course, is to look at it from a quantum meruit point of view, which means as much as deserved. So even if it is that you have done some work which you have substantially performed, you may get some payment for as much as you deserved having done the work. But again, it is taken on a factual basis. There are a couple of cases that I would ask us to consider here. One is Bolton and Mahadeva and Honig and Isaacs. Now, in Bolton and Mahadeva, it's a 1972 case, and there the Court of Appeal had to consider a case where the claimant installed central heating in the defendant's home. Now, the agreed contract price was £560. The defendant was not happy with the work and refused to pay. The defects in the work amounted to £174. The action by the claimant to enforce the payment failed, since the court said that there was no substantial performance. It wasn't done properly, and even when it was, there was a defect. When it was done completely, there was a defect. Look at the case of Honig and Isaacs, though, in 1952. Also a Court of Appeal case where the claimant agreed to decorate and furnish the defendant's flat for £750, which was payable by 2 installments and the balance on completion. Now, the claimant completed the work, but the defendant was unsatisfied as to some of the furnishings and refused to pay all of the final installment. Now, the cost of the defects in the furniture came to £56. The claimant, the court said, had substantially performed the contract, and as such, he was entitled to the contractually agreed price minus the cost of the defects. So you see that the courts are looking to draw on something that is just and fair, but at the same time taking it on the factual scenario as it relates to the contract. Now then, what if there is acceptance of partial performance? What does that mean to the relationship? Well, if a party freely agrees to accept partial performance or part performance, then a sum is payable for the work completed. The main focus here is on the free acceptance, because the idea is that I can't contract you to do something, you do half and then say, right, pay me, I can't bother to go any further. But if it is that we have agreed initially for you to paint the entire house, and then after you've painted the living room, I've said to you, no, I'm fine with the living room, actually, I don't think I'll go further, then frankly, I ought to be paying for the work. Case that we can look at for some guidance is Sumter and Hedges in 1898. The claimant had agreed to build 2 houses and stables for the defendant. It was agreed that £565 would be payable on completion. The claimant started performance and then ran out of money. So of course he was unable to complete. He had performed just over half of the contract. The defendant completed the work himself. The claimant sought to recover £333, which was the total of the value of the work he had completed. Now, he argued that in completing the work himself, the defendant had thereby accepted partial performance and should be prevented from succeeding, because that meant that the claimant, him of course, could not complete the contract. The court said that the claimant's action had to fail. The court said that the defendant had no choice but to accept partial performance. So this wasn't where the parties had agreed. He got to a point, he's run out of money, he stopped. Is it that the defendant is going to sit down and do nothing? Because of course, had he done that, there was a possibility then of the defendant finding himself in a situation where he had not mitigated his loss, for example. But the court said he had no option but to accept partial performance, as he was left with half a completed house on his land. What about tender of performance? Now, tender of performance can certainly be where you get a situation which is tied in to consideration. This is what it is. It is where a party is willing to perform, tries to tender performance, but the other party does not accept performance. Then the party seeking to tender performance, the law says, is discharged from the contract, and the non-accepting party is liable in damages for non-acceptance. So, you say to me, or rather I say to you, I need you to do some painting for me. We agree a price and all the rest. But over the weekend, I find somebody else who is going to give me a better price. You turn up at my house with your paint buckets, your ladder and all the rest of it, and I turn around to you and say, well, I'm not letting you in. Well, you have tendered performance as far as the court is concerned. So, what is the agreed price? If it is that we had agreed £100 for the painting, the court said it doesn't matter that you didn't paint. I was the one who prevented you. Tendering of performance is as good as performance. Now, a case in point is Startup and MacDonald in 1843, where a contract stated that 10 tons of oil were to be delivered to the defendant within the last 14 days of March. Now, the claimant delivered the oil at 8:30 p.m. on Saturday, March 31st. The defendant refused to accept the delivery because of the lateness of the hour. The court said that the claimant had tendered performance within the agreed contractual period and was entitled to damages for non-acceptance. What happens when the performance is prevented by the promisee himself? Well, where the promisee prevents completion of the performance, then the promisor is entitled to payment for the work which he has completed. And the case on that point is Blanche and Colburn, which is 1831. Now, in that case, the claimant agreed to write a book on costume and armor for the defendant as part of a series called the Juvenile Library. Well, the agreed contract price was £100 to be payable on completion. The claimant commenced writing the book and had completed a great deal of it when the defendant cancelled the series. The defendant refused to pay the claimant despite his undertaking and the fact that the claimant was still willing to complete. Now, the claimant brought an action to enforce his payment. The court said the claimant was entitled to recover £50 because the defendant had prevented the performance. Now then, a contract may, in some circumstances, be discharged by a breach of contract. Now, discharge as a result of a breach is something that is best left when we start afresh after the break that we're going into. As soon as we return, we will look at discharge as a way of, breach as a way of discharging the contract.